If you are a permanent resident, if you have a green card, can you be denied re-entry into the United States? Generally, the answer is no. Most people who have a green card cannot be denied re-entry into the US. But there are exceptions. One of the exceptions is if you have a crime that makes you inadmissible. Another exception is if there's a presumption that you've abandoned your residency. And that's what we're going to be talking about today. How to re-enter the US if you've spent more than 1 year continuously outside of the US. So if you've spent more than 1 year continuously outside of the US with your green card, there's a presumption that you've abandoned your green card. Presumptions can be overcome. You can rebut that presumption. You can counter that presumption and keep your green card. So let's go through an example of how you might rebut that presumption to be able to keep your green card, or alternatively, what might be a good option for you to re-enter the US and be able to continue living permanently in the US. So when you are outside of the US for more than 1 year continuously and you try to re-enter, there is a chance that in the airport, the customs officers can take you to a back room. It's called secondary inspection, and they can interview you to see why you spent so long outside of the US. And the purpose of this interview is to see if you intentionally intended to spend 1 year continuously outside of the US. Let's say you did intend to spend 1 year continuously outside of the US. Well, in that case, they would try to convince you to sign Form I-407 to voluntarily abandon your residency. But if you absolutely refuse to sign that form, they will generally keep you detained for a couple hours while they process you, and then give you a notice to appear in immigration court, and then they will usually release you into the United States. Now, this last part, you can be detained if they have a reason to detain you, and then an immigration lawyer is going to need to try to get you out on bond. But the chances of being detained if you have no criminal history tend to be low, at least in my experience. This is a good time to mention that I cannot tell you how many times people have been outside of the US for more than a year and then they re-enter and customs says nothing and just admits them back into the US. If that's the case, you're good. I would still speak with an immigration attorney before you travel again or before you apply for citizenship, especially citizenship. This can come up. They can later on try to allege that you've abandoned your residency. The chances of it tend to be low, but speak with an immigration attorney if you've ever spent more than 1 year continuously outside of the US before you apply for citizenship, because it can end up a disaster. Let's go through a hypothetical situation that I recently had with one of my clients. And I think a lot of people who have parents, for example, outside of the US, who've changed their mind and decided, you know what, I actually do want to live in the US, might benefit from this hypothetical. So I have a client, she's over the age of 21 and she's a US citizen. And her parents were residing in their home country, let's just say in Europe. I'm gonna hide as many identifying details in this hypothetical as possible while still giving you the gist of the scenario. So her parents were living in Europe and they've been there for like 5 years with their green cards. And so they've just assumed that they've abandoned their green card and that they won't be allowed back into the US. And I said, you know, not so fast. They never signed Form I-407. An immigration judge never ordered them deported. They are still, technically speaking, permanent residents, but there's a good chance that they're going to be heavily interrogated about why they spent 5 years continuously outside of the US when they try to re-enter. So we created a plan and the parents re-entered. When they were in the airport, the parents did not sign Form I-407 and they were detained and interrogated. And they were held for like 8 hours. And you know, the mother in this situation was really hungry. She felt like she was gonna pass out. It was very stressful. But at the end of those 8 hours, they received a notice to appear in immigration court and were released into the United States. So now they are in the US. Oh, and by the way, Customs and Border Protection took away their green cards, but they gave them a temporary I-551 stamp in their passport, which is temporary evidence of permanent residence for 1 year. And at the end of that year, they could always go and get another stamp in their passport to show that their current status is still permanent resident. So now they have removal proceedings pending. They need to show up in front of an immigration judge. And ordinarily speaking, the purpose of the court hearing in front of the judge is for the judge to actually determine what their intent was. But we have another strategy now. Since these parents entered the US lawfully, and since they have a US citizen daughter over the age of 21, our strategy now is to just readjust their status. Reapply for adjustment of status now that they're in the US. And by the time we get in front of the immigration judge, I'm hoping that they will already have readjusted their status to permanent residence, and we won't even need to defend or explain what their intent was and why they spent so long outside of the United States. This strategy, which is going to work in this scenario, might not work for everyone, and what it hinges on really is whether or not you actually end up signing Form I-407. If you sign that form, you're no longer a permanent resident. USCIS or CBP no longer needs an immigration judge to order you deported to take away your green card. There are only two ways to lose your green card legally: by signing Form I-407 and by an immigration judge ordering you deported from the US. If neither of these two things have happened yet and you're outside of the US with a green card, you can probably re-enter as a permanent resident, but you'll get placed into removal proceedings. So before you enter the US, you need to create a plan with an immigration attorney so that we can eventually fix your status. The story I just explained to you guys hinged on one key fact. The parents had a US citizen daughter over the age of 21 who was able to re-petition for the parents after they were admitted back into the United States. Anyway guys, that brings us to the end of today's video. I thought this was an interesting story. I know a lot of people who've had parents living outside of the US. Times are changing, conditions in some countries are deteriorating. If those parents have been outside of the US for more than a year and they want to come back into the US, or even if it's not a parent, if it's like a spouse who's been outside of the US for more than a year, when they come back, the key is don't voluntarily abandon your residency. Ask to speak to a judge and make sure you have a family member who could petition for you to readjust your status before you re-enter the US. If these two conditions are met, it's worth it to speak with an attorney to create a strategy before you enter the United States so you don't make any crucial errors during this process. If you guys are interested in these topics, be sure to subscribe. I try to put out at least 5 videos a week on family-based immigration, naturalization, and deportation defense. And I've also been putting out videos on changes to Trump's immigration policies. If you're interested in these, subscribe. If you need any personal assistance with your immigration situation, you can find my information for scheduling a consultation in the video description below, and I look forward to speaking with you and assisting you. I'll see you guys next time for another video.